Hi, this is Stephen Williams with the Real Debt Solution. I just finished with a client that's going to be going into court next week, and it's over a debt that's over 20 years old. Right now, we have collection agencies and attorney firms all across the country buying old debt, which is considered old paper, for pennies on the dollar. And what they're hoping to do is to take those people to court, hope that they don't show up and they get default judgments and they start this whole process over again. And even though they might have paid $10 for the debt, they're trying to get whatever they can out of it. Hundreds, some of them are thousands. One of the things that we found when we were preparing his documentation is that number one, it was past the statute of limitations, and there's really three types of statutes of limitations that you need to pay attention to. It varies in each state. The first statute of limitation that you always should pay attention to when dealing with debt collectors is if they had no contact with you for that specific debt within the statute of limitations time frame. Some states are 1 year, 2 years. In my state of Wisconsin, is 6 years. The other thing, that even if they have a judgment and they've done all the paperwork for the judgment, there's a second level of statute of limitations, which is, in my state, it's 20 years. According to statute 806.15, if they do not, regardless of what they do, if it's past 20 years, the debt just goes away. They have to allow you to move on with your life. Another statute of limitations is, let's say that they apply for what's considered a judgment and or slash lien extension. That's where, say they have a lien and a judgment against you and you didn't pay within the statute of limitations time frame, which is 10 years, then they apply to get it extended. Well, in this one, doing our investigation, we found that they would have had to do that by 2010. Right now we're in 2012. And what they're doing is they're hoping that this individual would not show up to court. They get a default judgment, whole process starts over again. Another thing that we found is that they may have been ripped off by the company that they purchased. So yeah, when we did our checked up on the documentation and checked on the court files, original judgment amounts, it was $3,000. It wasn't over $30,000 like they're claiming. So they may have been ripped off by the company that they purchased it from. So what you want to do is you always want to check those things in your state. It varies in state to state, but don't let these debt collectors take advantage of you. What they're hoping is that you won't show up to court. They get a default judgment. Another thing that I told my client to do, and which is something that is, you want to do it because you want to express your feelings and your opinions in court, but court is not an area for you to do that. I know we see these cases on TV and we see people doing it, but really court is about the law. And if you approach it from a legal standpoint by just telling the judge to please look up the statutes and different things that should be, that's just plain and simple in writing, they have to look that up, and then they will go by what's in the law. They won't just make up things for you. So please, when you ever get stuff from bill collectors claiming that you owe a debt, always respond. Never acknowledge that you owe something that you don't owe, and then make them prove all the documentation by you showing up to court, and also send the letters within the specific time frame that you must do that. That's according to the documents that you get from the court.